We are on this Here we are on this very hot day to discuss the hottest of topics, the potentially huge and exciting change in the way in which the finances of separating couples in England and Wales are dealt with. In particular, we are here to discuss the contents of the government's consultation paper published just a few weeks ago under the title A Fairer End to Relationships. This paper, of course, is the carefully considered government response to the Law Commission report of December 2024. Here, perhaps, is a once in a generation opportunity to make some really important changes to the area in which many of us here work. Of course, the headline change is the suggestion that for the very first time in England and in Wales, of course, been in the case in Scotland for a very long time, that there should be a right for separating non-married cohabitants to seek capital and maintenance orders. And the Court of Appeal for action in Burns and Burns in 1984 finally possibly is getting some traction, notwithstanding the Law Commission blueprint paper of 2007, which has until now been pretty much ignored by governments of all colours. There is, of course, in addition to that, the possibility of a written codification of the current financial remedies law, maybe with specific and targeted additional reforms or pluses in the areas of domestic abuse and nuptial agreements. And there are some significant changes to the position of cohabitants where a partner dies intestate, a very real problem for some when this happens. So, under these headlines, there are, of course, lots of details, some which are very important to the way that these reforms might operate. And tonight, we have put together a distinguished cast of contributors, all very knowledgeable about this subject and particular parts of this subject. We have Nicholas Allen Casey, a leading family silk specializing in financial remedies, as well as Deputy High Court Judge and a prodigious writer on all things financial remedy. We have Professor Emma Hitchens, a Professor of Family Law at Bristol University, leading family law academic and the lead author of the Fair Shares Project, with its excellent paper, Fair Shares, which is quoted, I think, more often than anything else in the government's paper. So congratulations to Emma for that. We have Professor Sharon Thompson, Professor in Family Law and Legal History at Cardiff University, who's long taken a keen interest in particularly in the subject of nuptial agreements and is the author of a book, The Road to Equal Partnership, discussing models for reform in the light of the Law Commission scoping paper. We have Anita Mehta, leading family barrister, deputy district judge, and co-lead author of the important resolution paper, Domestic Abuse in Financial Remedy Proceedings. And of course, Anita is a regular and powerful speaker on this topic. We have Charlotte John, who's a leading chancery barrister, but has firmly one foot in the world of family law, is a contributing editor of the Red Book, a deputy district judge, and a member of the editorial board of the FRJ. And last but not least, we have Rhys Taylor, leading family barrister, recorder, and editor of the Financial Remedies Journal. So our plan for tonight is to seek the thoughts and views of the panel, both in taking an overview of the proposed reforms, but also to look at the different areas that it covers in a bit more detail, and also to kick the tires of the proposals and see if there's any room for criticism or improvement in the details of its individual constituent parts. So we're going to start tonight by asking Emma Hitchens, would you like to give an overview of this consultation paper and give us a feel for how individuals, perhaps the people who are watching our webinar tonight, can get involved in what should happen next? Emma.
Thank you, Edward, and that's great. Good evening, everyone, and on this very hot, sticky evening. So just a brief overview then of the consultation paper itself. As we all know, and as Edward's quite rightly said, there are three elements there: financial remedies reform, reforming the law for cohabitants on separation, and also reforming the law for cohabitants on intestacy. I think what is important as well is actually to look at the four principles underpinning the government's approach to reform so that we can analyse the potential law reform in light of these proposals. So these are sort of prioritising fair outcomes for children, so putting children's welfare at the centre of decision making, protecting the vulnerable, which is a key sort of underpinning principle that they're looking at with reform, providing a clear and accessible framework, which we saw with the Law Commission's with the law previous consultation paper as well, and also preserves the distinct legal status of marriage with enabling protections for cohabitants that are clearly differentiated between marriage and cohabitation. Now, in terms of financial remedy reform, the government's consultation paper is recommending a codification plus model, codifying certain case law principles into statutory reform, but also inviting further views regarding targeting reforms, including introducing qualifying nuptial agreements and whether the court should give greater weight to the impact of domestic abuse when determining financial needs and outcomes for both divorcees and also for separating couples. In terms of the focus, which we'll look at, I will look at the focus on the financial remedy provisions for now. The proposed overarching objective for financial remedies on divorce in the consultation paper is that a fair outcome should be achieved through the principles of sharing and needs. And this can be contrasted with the proposed overarching objective for cohabitants, which is that a fair outcome would be achieved through the application of the needs principle only. So needs and sharing for divorce and divorcing couples, and needs principle only for cohabitants. Now, a key principle here again is that the sharing of matrimonial property would be the court's starting point for financial remedies on divorce, unless a departure is required. So, for example, to meet the parties' needs. And the consultation proposes using distinctions between matrimonial and non-matrimonial property as per Standish. Where it then moves on to that second stage where the needs principle is used, the government is then suggesting introduction of an objective for needs. And also in terms of how the needs objective should be applied, they're suggesting a three-stage approach to needs. Stage one being that children needs come first. Stage two, that we consider divorcing couples' capital and income needs, which it will include housing and pension needs as far as resources allow. And then on to stage three, which would be considering discretionary needs where resources permit. And that they're considering within the consultation paper would be lifestyle luxuries such as expensive cars, designer items that they put in the consultation paper. All of those needs, they suggest, will be benchmarked against the standard of living during the marriage, so as far as resources allow. And then this will be compared with the approach to separating cohabitants, separating cohabitants will use only stage one and stage two. They would not have the discretionary needs approach. In terms of your second question, that's a very brief overview of financial remedies and cohabitation. I haven't even looked at the domestic abuse, intestacy, prenuptial agreements. I'll leave that to others. But in terms of how can individuals respond to the consultation paper, it's a 10-week consultation. It closes on the 14th of August, and responses can be made through an online form. So we would definitely encourage individuals to go online and fill out their responses. Not all questions need to be answered, and individuals can choose to answer as many or as few as they would like.
Would you care to give the government a mark out of 10 for what they've done so far? Or
Oh, God.
do you think they could have done, but what areas have they missed out, which they could have included? What do you think?
Well, I don't want to sort of start on a hiding to nothing with actually giving a mark out of 10, but what I will do is I can give you some positives and then possibly a couple of areas where I feel that we could look at it in a little bit more detail. I think a lot of this is positive, and I think we have to be very, focused. Say this, as you said earlier, it's a once in a generation opportunity to legislate for cohabitation reform. And we do know from a range of research that's been done, academic research over many years, as well as practitioner experience of advising cohabitants, how the current law does not protect the vulnerable. It doesn't prioritise children. It doesn't provide clear and accessible framework for separating cohabitants. So in those elements, we really have to say it's a positive step change, and we really have to welcome it. Also, I think another positive aspect of the consultation paper is that it invites views for targeted reforms, particularly with regards to domestic abuse, also with regards to pensions as well. So there's a really useful opportunity there to provide our views and to feed into opportunities going forward. I do think the four underpinning principles are clear. We know, and I know as the principal investigator on the Fair Shares report, where many of our findings spoke to vulnerabilities experienced by certain groups within the divorcing population. It's very reassuring that one of the four underpinning principles within the consultation paper is protecting the vulnerable. And I do think at various points that comes through in the consultations papers, discussions and recommendations. I also think it's another positive in terms of it's the importance of flexibility is also highlighted within the consultation paper. I mean, again, with the Fair Shares finding, we highlighted the importance of flexibility when dividing assets on divorce, particularly for those with fewer assets to divide, as this would help to assist with a fair and effective distribution. And I think the Codification Plus model that they've used is, I think, a positive approach. It allows for that continued discretion, but it will hopefully enable some clarity to come through from codification of the existing law and also the other potential issues. From my own personal perspective, I was delighted to see that ongoing periodical payments for spouses speaks directly to our findings in the Fair Shares research, that ongoing periodical payments are rarely used, and where they are, they're really used for a fixed term and tied mainly to a recipient's childcare responsibilities and their needs. And it's really good to see that the consultation paper is not going to limit spousal periodical payments in that way. So I think those are really positive takeaways from the consultation paper. I do have some elements where I would say that I would kick those tires, so to speak. I think one of the potential issues, and I'm going to look at this from the perspective of being the PI on the Fair Shares project and looking at it from an everyday needs-based case, particularly for those individuals who don't receive any legal advice and those who don't go to court, but really are still bargaining within the shadow of the law. And so I would suggest that whilst I can understand why the government has used sharing as the starting point, amongst other reasons, of course, differentiate between married and cohabiting couples and separation, I think my slight concern with this approach is that it's focused on the approach in bigger money cases. But also we know from Fair Shares that many divorcing spouses they have very limited, if any, legal advice or assistance. And we also know that the concept of the ownership of an asset is a key factor in the division of assets for certain types of divorcee. So, for example, our housemate typology looked at those individuals who took an individualistic approach to their relationship and considered ownership of an asset when important at looking at overall division. So in light of those particular findings from Fair Shares, I'm slightly concerned that divorcing couples who are making their arrangements completely outside of the court and without any legal advice could take that 50-50 starting point steer in the legislation and use it as the basis for their division of assets without going to that second stage needs assessment, nor looking at non-matrimonial property to address those needs. And I think a risk that I would suggest is a potential risk is that the equal sharing starting point is that for husbands and wives without the benefit of legal advice may also assume it's the finishing point as well. And I think that is a potential risk.
Well, thank you very much, Emma, for that overview. That's very helpful. Now we're going to take a slightly deeper dive into some of these proposals. And I'm going to start with the codification part of this, the codification of existing financial remedies law. We'll come to the pluses later on. Nick Allen, is this a sensible thing for the government to attempt? How is it to be done? Who's to do it? How will the codification of things like needs and standish matrimonialization issues work in a codification? Nick?
If I knew the answers to all of those questions, Edward, I'd probably be doing a different job to the one that I do, but I will do my very best to answer as many as I can. I think from a financial remedies perspective, with the exceptions of giving greater status to qualifying nuptial agreements, and secondly, a potentially significant change in relation to the impact of domestic abuse in the quantification of financial remedy awards, and in particular, to what extent, if at all, the conduct has to have measurable economic consequences. I think subject to the outcome of the consultation on those two potentially very important points, I'm not sure there'll be a huge change to how we deal with financial remedy cases on a day-to-day basis, in comparison, of course, to the fundamental changes to cohabitation and to intestacy. The consultation makes it clear, as Emma has said, it's going to be driven by an assessment of the needs and the sharing principles, with the sharing principle being looked at first, and that being the end, with all the potential concerns in relation to that Emma has identified, unless needs outweigh sharing. Now, is that very different to what we have at the moment, where we say an applicant gets the greater of needs and sharing? I'm not sure that's hugely different to that. Interestingly, the government has agreed that we all struggle with the compensation principle, obviously introduced in Miller McFarlane in its present form 20 years ago in 2006. And whether the correct term is relegated, I don't know, but I think that one of the limited amendments to Section 25 that is proposed is effectively folding in compensation, or perhaps as described, relationship generated disadvantage, into the explicit factors that the court will need to consider in the Section 25 exercise. But as many judges have said, if a party has a need as a consequence of the relationship, is that very different from considering relationship generated disadvantage under a compensation heading? So query to what extent that will make a difference. I think one of the particularly interesting areas is codifying the non-matrimonial property, matrimonial property distinction, which we are all very familiar with, but is often easier to identify in theory than it is to apply to the facts of a particular case. And the government consultation makes it clear that they intend to copy and paste a lot of the judgment of the Supreme Court in the Standish decision in the Supreme Court last year into its statutory amendments in relation to the distinction between non-matrimonial property and matrimonial property. And I think that presupposes that the Supreme Court has left us with sufficient clarity in relation to the distinction between the two types of assets, and more particularly how we deal with matrimonialization as a concept. And it is self-evidently clear from the 3 or 4 first instance decisions that have sought to apply Standish, and by that I mean the citable first instance decisions that have sought to apply Standish, that there is not a uniform approach being adopted by first instance judges. And I think of 2 decisions of Mr. Justice Cusworth, 1 decision of Sir Jonathan Cohen, and Edward, of course, your decision, particularly with the meaning of use of enjoyment in relation to pensions, which of course has been certified as citable on the issue of matrimonialization. And so if 12 months on from Standish, we are getting, as you would expect, slightly differing first instance interpretations of Standish, it must give pause for thought as to whether or not there is sufficient clarity in Standish in the Supreme Court to translate that into statutory wording. Obviously, Edward, in your decision, you were wrestling with the phrase use and enjoyment, and you obviously opined as to whether use and enjoyment of a pension could be matrimonialized, where self-evidently a pension enjoyed during a marriage which had not yet been taken by either party could still be matrimonialized, even though it self-evidently couldn't be shared during the marriage and could not be used and enjoyed during the marriage. So there is debate, obviously, in relation to that phrase. I don't think any of us, other than in the kind of sense of how you were dealing with it in your case, Edward, have a difficulty with the concept of use and enjoyment, nor do we probably have a difficulty with the use of the phrase over time for how long an asset has been, for want of a better term, mingled, utilized over time. But that may beg the question, how long is over time? I think the greatest difficulty that practitioners have had with Standish is the potential relevance of subjective intention behind matrimonialization, because use and enjoyment is something that is objectively verifiable or could be subject of a relatively easy finding of fact. Over time is verifiable, can be subject to a finding of fact. But the introduction of subjective intention obviously introduces elements that those who do trusts of land work are much more familiar in the context of constructive trusts and estoppel, and query whether the introduction of intention will do anything other than confuse, if that is the level of granular implementation of Standish that we get. And my other final point in relation to the government's adoption of Standish is the government seems to be of the view that if something is matrimonialized, then it should be divided equally. Divided equally is not necessarily divided fairly. And I wonder whether a better formulation might be that if an asset is matrimonialized, whatever the test may be, that it is then subject to fair shares rather than necessarily equal shares. So in short, in terms of matrimonialization, I think a lot of good comes from codification plus of the existing case law, but elements that we are still grappling with at first instance, seeing that put into statutory form could cause some difficulties in relation to needs. Children's needs obviously come first within section 25 as is. Query whether then delineating between meeting a party's capital needs and income needs second, and then for example, discretionary needs in a luxury category as the third category, again, may potentially raise as many questions as it answers, because we all know in the context of Schedule 1 and what we used to be called the carers allowance, what is for the benefit of the child and what is for the benefit of the party who is the carer of the child is often a fraught subject. And it may be relatively easy to know that air conditioning in the south of England isn't a need, although, Edward, you may want to revisit that in light of the current climate position. You probably don't revisit whether or not AstroTurf is a need, but query whether we're setting up more scope for argument at the delineation between capital and income needs and discretionary needs.
Well, you're making me feel guilty. I'm sitting in the very well air-conditioned Central Family Court at the moment, and that's why I've got my jacket on. But let us turn to a deeper dive into the pluses. Thank you for that, Nick. And I look forward to the exercise of writing the codification. It will be a drafting exercise of drafting exercises, I suspect, which will be interesting to see how they attempt to do that. Let's turn to some of the pluses of the codification. Two ones, really, which the first of which is nuptial agreements. And this, of course, has been a hot topic for quite a few years, and now taking a move forward. Sharon, you're an expert in this subject. You've written a book which contains a lot about this information. What would you like to tell us about this in the context of these reforms?
Well, the government has proposed to make nuptial agreements binding. And what they've proposed is that they will be binding if certain safeguards are in place. So I think most people will be familiar with this idea of the qualifying nuptial agreement, where that comes in. If you tick the boxes, you comply with the safeguards, the agreement qualifies. And those safeguards that they've proposed are mostly procedural, such as the agreement must have been made more than 28 days before the wedding or civil partnership. There has to have been material disclosure, independent legal advice, and it's not possible to waive those rights to independent advice and material disclosure. So those safeguards will be fairly familiar to many people watching, because they mirror, of course, what the Law Commission suggested in 2014. And the government has proposed that these procedural safeguards would actually apply to opt-out cohabitation agreements as well. Where it starts to get more interesting, though, is how the government deals with needs. And of course, in 2014, the Nuptial Agreements Bill, it included this substantive safeguard saying that an agreement could not contract out of needs. And in that context, needs meant needs, as it would be interpreted by the court absent an agreement. Here, though, the government is proposing that needs should be assessed on a narrower basis, as they would be assessed under the proposed reform for cohabitants as well. And this is through the three-stage approach to needs that Emma has already outlined. So just very briefly, that's the stage one, first consideration to the welfare of the children. Stage two is the parties' capital and income needs being assessed. And then stage three, which is where resources permit, the court can consider what the government refers to as a discretionary needs stage. So this is stage three, or tier three. Now, as Emma has said, discretionary needs are described in the consultation paper as relating to lifestyle luxuries, in other words, beyond that sort of provision for housing and pension needs, but which a court might nonetheless consider appropriate where there are more assets to go around. And as I've said, what the government is proposing is that parties to a qualifying nuptial agreement do not get access to this stage three, or tier three of discretionary needs. So if you signed a nuptial agreement, you don't access that final layer. And that's what makes these proposals really different, actually, from what the Law Commission was saying in its 2014 Nuptial Agreements Bill.
Could I ask a question?
Yeah, of course.
In your book, The Road to Equal Partnership, you give a striking example of the fuss and the foresight that goes into choosing a wedding dress, and then the sort of last minute manner in which some nuptial agreements are cobbled together before the big day. And I was just wondering whether, with all of the work you've done in this area, whether you consider 28 days is enough, or whether you would have a longer period of time.
It's a really good question. It's difficult to know, because there's always that idea that it will artificially move the negotiations to the last minute, depending on where that sort of cooling off period lies. I suppose if the agreement needs to be signed at least a month before the wedding or civil partnership, at least it's not kind of going down to that sort of story of the day before the wedding, the sitting in the car waiting to go into the venue or whatever. But I do agree that it's something that
lots of things are booked by 28 days before.
Yes, absolutely. And I think in an ideal scenario, the agreement negotiations would have begun before things like the wedding dress is ordered or the venue is booked, as you say.
Thank you.
Right. So, do you think that these reforms are going to have, if they're implemented, a significant change in the way which nuptial agreements are dealt with, or is it going to end up quite similar to what the law is now?
Well, I think that there are quite a few implications if this reform is introduced as is, and it really all comes back to that decision to narrow needs. I think there is a risk of unfairness actually when it comes to scaling back needs, because if you strip away anything beyond the provision at stage 2, the capital and income needs, you could potentially end up with one party, of course, having a much higher standard of living after the divorce, with the other person reduced to something much more basic even after a long marriage. I think also it has implications earlier on as well at the point that the agreement is made when it comes to power imbalance. And that's something that I found in my research, this idea that the idea that needs must be met can put some pressure on the wealthier party at the negotiation stage to negotiate more reasonably. So if you weaken that sort of needs safeguard, which I guess is how it's operating, you are potentially weakening the bargaining position of the financially weaker spouse when that agreement is being made. Another issue is that I think although the reforms are framed as increasing certainty, this third tier of needs might actually generate some new uncertainty. So these concepts around luxury and discretionary needs are potentially very subjective, because of course what is ordinary in one household might look extravagant in another household, and there's real possibility of litigation around that. So I think as a result, as this is refined going forward, that I think this meaning of discretionary needs to be defined quite restrictively. I think there's also a broader point about how we understand marriage. So, if marriage is meant to be an equal partnership, as I argue in my book, it certainly should be. I think it's quite problematic then to label elements of needs as extras that one party can simply contract out of, because I think that in itself risks shifting the weaker party into the position of the needy supplicant, or the lesser moneyed spouse even, rather than as someone who is entitled to an equal share of what was built up during the relationship. So overall, I would say it's really good to see recognition that nuptial agreements should be made binding. I would be in favour of making them binding under legislation, but I do think that overall, as Emma has already said, the government's clearly concerned with protecting the economically vulnerable spouse here. And with that in mind, I think it's really important for the proposals to be tweaked so that nuptial agreements can be binding, but that the needs of the parties should be met, and those needs shouldn't be limited. I think they should be the same as the needs of people who don't have a nuptial agreement. And the reason for that, and perhaps the most important thing to note, is that under this proposed reform, needs really is the only mechanism by which the court can account for changes in circumstance between the signing of the agreement and its enforcement on divorce. So things like relationship generated disadvantage, things like domestic abuse even, and restricting needs could therefore make it plausible that unfair agreements would be given effect. So even though the current approach, as you say, is that sometimes needs can be assessed more conservatively in the case law, I think this is a real opportunity for legislation to make prenups binding and say no needs means needs.
Reese, you have another question?
Yeah, sorry, can I chip in with another question, Sharon, which is what of those nuptial agreements which for some reason don't qualify as qualifying nuptial agreements? Where do you see those landing in the future?
I would have imagined that they wouldn't be binding in the same way, but I'm not sure how they would work. That's a really good question.
Will they sort of
I
will the
suppose
case law that we currently have continue in respect of those, or will that case law be dragged up and, for instance, full disclosure and legal advice, become more important, even in that context, perhaps?
I would imagine so, that the requirements of independent legal advice and seemingly my understanding is that in practice those safeguards under the nuptial agreements bill are currently almost like a kind of guideline to ensure fairness. So I think that I would hope that those agreements signed on the eve of the wedding, that they are more difficult to put into place, because there is a kind of suggestion of real pressure there. And I suppose having legislation to make nuptial agreements binding would certainly raise that as an issue.
Thank you very much, Sharon. So let's move to the other big plus, which is domestic abuse. This is obviously a controversial area, but Anita, would you like to talk us through what you think about the government's proposals in relation to this subject?
Well, it's funny you should start by calling this a controversial area, because I have always thought that I get invited onto these things because I am the barrister who is brave enough or foolish enough to be saying things about domestic and abuse and conduct, which up until now have been thought of as controversial. But now what I can confidently say is, oh, it looks like the government agrees with me. Perhaps it wasn't so controversial. I could make a big play about that, but it's far too hot. I don't have air conditioning. I've turned my fan off just for this moment. So I won't crow. And I should be careful really about what I'm saying, because unlike other parts of this consultation where it is really clear what the government is going to do about the concerns it has identified when it comes to conduct and it comes to domestic abuse, the questions are asked in an open fashion. So they haven't identified specifically what it is they're going to do. And effectively, they are genuinely coming out to consult in respect of that aspect to see what it is that can be done about domestic abuse, when it should be taken into account, how it should be taken into account. And that is different to when you get through to reading the other 140 odd questions. So what I say is it's all to play for when it comes to conduct and domestic abuse. So the government says, when should conduct and domestic abuse be taken into account? Well, what I say is this: we have known since 2024, when Resolution did its report, that practitioners were saying that it is not given sufficient weight. We know at that point, 80% were saying it's not given sufficient weight in financial remedy, 87% in Schedule 1, and 90% when it comes to cohabitees. And that chimes with the government's finding that it is particularly cohabitees who are vulnerable because, of course, they don't have recourse to family law remedies. So what else does it go on to ask? Well, it's asking, when should it be taken account? When is it appropriate to do that? And what I would say to that is, most practitioners agree there should be some sort of threshold when it comes to domestic abuse. The question that the government is asking is, should it be a question of exceptionality? And what we know is that nowadays domestic abuse, and in fact when the statute was also written, I suspect it was the same, but certainly nowadays we are very conscious of the fact that domestic abuse just isn't exceptional. It all washes up into our courtrooms, I'm afraid. And therefore the effect is that if you come in front of a judge saying, look, there's a background of domestic abuse, it is just impossible to make that judge gulp, let alone gasp, because the judges are seeing just so much of it. So I say that is right, that there should be a change to that. I say it is also right that it should be clear there doesn't have to be a financial consequence. I could talk about this for a long time. There's a difference in interpretation, I would say, as to whether the higher courts have required a financial consequence to be proved in respect of domestic abuse. Perhaps we're never going to get the answer now from the Court of Appeal as to who was right on their interpretation.
Could I ask Anita
a question? Yes.
If there's not, if there doesn't need to be a financial consequence, so in those cases where there's egregious domestic abuse but no causal financial consequences, do you have any thoughts about what the guiding principles might be for adjusting an award to take domestic abuse into account?
I'm getting nervous now that you've got your hand up and Nick has got his hand up. I'm really worried that the chat function is going ping, 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 and I can't see it. And I definitely don't want to give Edward the opportunity to ask me a question. So I'll just try and talk out my time so he can't ask me anything about that. I don't think it's that hard. I honestly don't think it is that hard. Our judges are adept at coming up with a solution when there are so many discretionary things. And I understand that this act is about giving certainty. But for those of us who practice in this field, in respect of many discretionary aspects, we know what bracket the judge is going to come into. We know what's going to be, what bracket of property is going to be considered non-matrimonial or matrimonial. We know quantums of maintenance. We know what discount might be applied in respect of liquidity. So I think that the judges can do it, actually. If you give them the legislation, they will do it, and I'm sure they will do it fairly. But if the government was concerned about it, when it's kicking its tires, of course, it could just identify the bracket. I'll pause there, although I hope
Nick,
you can ask me something.
Nick, you've got another question.
Anita, my question was simply going to be, I found it interesting when I was reading the government consultation that in the area of financial remedies, this was probably the one area where the government didn't express a view, and as you say, posed it as a very open question, and its various alternatives reflect various interpretations of the case law. Do you have a view as to why you think the government approached it in that open way, rather than expressing a provisional view as to what it might be minded to do?
Anita?
I do.
Yes.
I do. Edward probably has a view as well, because if you read the Law Commission report, what you can see is that the judiciary said conduct should not be taken into account. Now, they didn't say that on a principled basis. I'm not talking about individual judges. Obviously, I'm talking about collectively. All of the judges, almost all of the judges that the Law Commission spoke to said conduct shouldn't be taken into account because of concern about resources and how the court can cope in respect of that. But the government has given its answer to that, hasn't it? It's done its costings. I don't know whether the costings are right or not. I'm just a family barrister, so I'll stay in my lane about that. But it's worked out in its assessment that if it makes the law certain in more places, then it can give more rights to the vulnerable, being cohabitees, and more rights to the vulnerable, being those who are suffering abuse.
So are you confident, Anita, that the government will give the extra resources to the FRC that this change might demand?
Well, that's not what it says in its assessment as I read it. What it's saying is we're not giving you any more resources. What we're giving you is more certainty. And with that more certainty, there's going to be less cases, and therefore you don't need more resources. That's how I interpreted the assessment. But is
that likely to be correct, do you think?
Didn't I just say I was going to stay in my lane for once and just answer as a barrister? Do I have to answer that question?
No,
I mean, what I'm saying is the right should be given to the vulnerable. And at that point, I would like to get off what is actually a very hot seat right now, being grilled by all of you, and pass over to whatever questions there are for Mr. John.
Okay, well, thank you very much, Anita, for your usual brilliant presentation of this topic. And it'll be interesting to see how this all develops. But we're going to move to a slightly different area at this point. And I'm going to bring in Charlotte at this point, Charlotte John. And I'd like you to tell us about the cohabitation bit of this in detail. What do you think the politics of this are? How does it all fit in with Schedule 1 and Talata applications from the point of view of a Chancery barrister? How's it all going to work? Charlotte.
All right, thank you. Well, many of you by now will have seen the consultation paper or read about the proposals, and some of what I've got to talk about is being foreshadowed by what others have said. But just to briefly sketch what's being proposed, unless parties opt out, and that is a potential option, cohabitants will be eligible to bring financial provision claims after 3 years of cohabitation or immediately if there's a child of the family. It's also proposed that there's to be a 2-year limitation period, so following separation, 2 years within which to bring a claim. And others have already spoken about the tiered approach to needs under the proposed reforms. So provision for cohabitants is to be limited to essential needs, including potentially capital needs for housing and pension provision, but precluding provision for the sort of discretionary luxury lifestyle needs that also are to be treated as being this sort of tier 3 level of provision for the financial remedy proposals. So I think we can all envisage that in terms of what the provision will be for cohabitants, that there'll be quite a lot of definitional wrangling about that dividing line between what amounts to a discretionary need and what amounts to an essential need that provision can be made for under the proposed proposals. I've got some tech problems here, so I'm hoping you're all still with me, but I think my computer's possibly suffering from the heat. And in terms of sort of teasing out some of these the policy considerations, the political considerations that have shaped the proposals here. Well, I think in the first instance, very positively, there's clearly been a deliberate policy decision to cast the net wide by making this an opt-out scheme and proposing quite strenuous requirements if you're going to go through the mechanics of opting out. So similar to the proposals for prenuptial agreements, parties would need to have independent legal advice and financial disclosure before opting out. So one imagines that it will be better resource parties that go down that avenue, perhaps those that are already electing to make a declaration of trust, maybe if they're buying a property together, perhaps it will be thought about at that point. Or one imagines possibly parties in later life relationships who want to preserve capital for children from a first relationship or an earlier relationship. One hopes that those will be the parties that think about opting out, but otherwise anybody who doesn't take that option is going to be within the remit of the scheme. And looking at the architecture of what's proposed, it's clear that the government is endeavouring to try and strike a balance in terms of coming up with a scheme that can be sold to the critics of cohabitation reform as being both structurally distinct from and more limited than the provision that can be made as between separating spouses. And we see that policy choice manifesting itself in this distinction between essential needs and discretionary needs, ruling out of the sharing principle, so there'll be no concept of cohabitation property to be shared between the parties, as well as the steer towards the early termination of financial independence by the proposal that periodical payments be limited to exceptional cases, such as cases where there are serious health issues or something of that description. Now, I have to say that that's one aspect of the scheme that I'm somewhat less enthusiastic about, I think, because I imagine that there will be lots of cohabiting couples where there is income disparity, particularly where one party has had time out of the workplace to raise children, but there isn't actually any capital to be shared. So I hope that views will be expressed about that, and we'll see where we end up in relation to that. And in terms of what does that leave by way of Talata, I'm afraid that my computer is shutting itself down, so I'll keep talking and hope that I stay with you. But there will still be a role for Talata claims. Talata will still be applicable where parties have elected to opt out. Talata will still, or trust of land principles will still have to be thought about in any case where the shares that the parties would have by way of beneficial ownership might exceed the provision that they would receive by way of needs. So we'll still have Talata claims there. And also there'll still be a role for Schedule 1 in cases where parties have opted out, because it is proposed, and there's a question about this in the consultation, that it should not be possible to, for good reasons, bearing in mind that it's to do with provision for children, that it should not be possible to opt out of the provision for children under Schedule 1 of the Children Act. There's one little bit of what strikes me as being sort of political theatre in the proposals, which is being suggested that there should be a specific provision requiring the court to ensure that the standard of provision does not exceed what would be made between a couple in an equivalent position on divorce. But if you've already got that lower standard baked into the scheme, if you're already saying you can't have discretionary needs and you can't have sharing, then this is window dressing, I think, really, which is about flagging to anybody that might be opposed to the scheme that this is distinct and lesser than the provision that you would get on divorce. One point that hasn't been mentioned in the consultation paper, and be interesting to see how this intersects with the position on death. You can't currently opt out of the 1975 Act. Under the 1975 Act, we take prenuptial agreements into account in much the same way that you would on divorce, but it isn't possible to opt out. And I wonder, is there going to be any thinking about that? Will that be a possibility, or will it be possible to opt out of financial provision during lifetime, but still have the possibility of a financial provision claim on death? So that's the scheme in terms of what's proposed by way of financial provision for cohabitants. I'll also touch on I can see Reese has got his hand up. Yes.
So would you like to deal with the second part of your brief here, which is really the inheritance point?
The inheritance provisions.
We'll let Reese ask a question at the end of that. Yes.
Certainly. So looking to the position on death, the main proposal is to grant qualifying cohabitants the same intestacy rights as for spouses or civil partners. So for cohabitants that meet the eligibility criteria, that will mean the full estate if the deceased had no children. If if the deceased dies with children, then a qualifying cohabitant, as with a spouse, would receive a legacy of £322,000. It's very specific. I don't know why it's that figure. Plus the chattels, plus half of the residue. Now, there's no proposal at this stage to change the inheritance tax regime. You will probably know that anything left to a spouse is exempt from inheritance tax. That's not the case for cohabitants. So whether that changes will be a matter for Rachel Reeves, but doesn't seem to be a matter for this consultation. I don't know what others think, but that strikes me as being possibly one of the more controversial aspects of the reform proposals, the intestacy proposals. I think we would all be on board with the idea that cohabitees should take on intestacy over some distant cousins that the deceased hasn't seen for years, or over the estate going bona vacantia for the Crown. Who would disagree with that? But extending spouse equivalent rights to a cohabitant will result in disinheriting or substantially reducing the provision for minor children. And that impact will be most keenly felt by children from previous relationships. Now, those children can pursue 1975 Act claims, but that then places the burden of litigation on minor children, which is, to my mind, not ideal. So in recognition of the fact that these are very significant changes that radically change the landscape for inheritance rights, there are additional qualifying hurdles that are proposed to be built in. So the first is that it's suggested there be a different definition for cohabitation when it comes to assessing intestacy versus the definition on separation. So for the lifetime scheme on separation, provision will be available where cohabitants are in an enduring family relationship. For the intestacy proposals, it is suggested, in line with the 1975 Act, that the question will be whether the parties are living together as if they were husband and wife or civil partners. Now, Personally, I wonder if that is a distinction without a difference. What more does living together as husband and wife mean, if not living together in an enduring family relationship? The 1975 Act case law already takes a very flexible approach to cohabitation, recognises that there's a variety of different relationships that can still be construed as living together as husband and wife or as civil partners. So I'm doubtful that that actually is a meaningful distinction. The second proposed hurdle is about the minimum length of cohabitation before cohabitees acquire intestacy rights. So it is being proposed that you should have to be cohabiting for 5 years before you will be eligible for provision on intestacy, where there are no children of the relationship. But if there are children of the relationship, then the government is floating a reduced 2-year qualifying period. I mean, this is very interesting, and I would predict lots of litigation over the qualifying criteria. All other intestacy statuses are hard-edged. They're readily proved by way of a marriage certificate, DNA testing, genealogy research, whereas this involves cohabitation, which is something which is more fluid, more of a fact and degree sort of a status. So there's bound to be litigation over that. And then the other tweak that the government's proposing is in relation to parties with shared children. The government is suggesting dropping the requirement that exists under the 1975 Act, the Inheritance Act, that a couple must have been cohabiting for the 2 years immediately preceding death. So where there is a survivor who has a child with the deceased, they will have immediate eligibility to bring a claim regardless of the length of the relationship. That's what's being suggested. I think that's probably sensible, seems to me a relatively minor change. It probably won't impact on many estates because many people that are in that position where it's a shorter relationship in terms of the cohabitation length, but they have a child together, they would still qualify most likely as somebody who is being maintained wholly or partly by the deceased immediately before their death. So people of that description, dependents, they have standing to pursue claims. So that's a minor tweak. There are a couple of points, if I've just got time to touch on, where the government hasn't thought about things that need to be thought about. And the first is, you may know that with spousal claims under the 1975 Act, you have to think about the deemed divorce cross-check. So you think about, well, what would have been the level of provision if this relationship had ended in divorce instead of death? And the question I ask is, should we not also do that with cohabitation claims? I think probably yes, because there are differences in the approach to provision under the 1975 Act and with what's envisaged under the cohabitation reforms. And what we don't want is a cohabitant on death achieving lesser provision than they would achieve in life. And the other point that I think needs to be thought about and hasn't been mentioned in the consultation is we should really have now a new category of former cohabitee that can bring a claim. Think about the position of somebody who has separated. They are still within the 2-year window to bring a lifetime provision claim, or maybe even that claim is on foot, and then the other party dies. Why should they not be able to bring claims under the 1975 Act? Because presumably, as with spousal claims in life, that cohabitation claim will end with the death of one of the parties to the relationship. So that's just a couple of thoughts from me that haven't been thought about.
Thanks, Charlotte. There's some brilliant stuff there, really interesting stuff, and lots of detail. Reese, we've only got a few minutes left before our time is up. Wrap it up for us, if you wouldn't mind.
Yes. Okay. So I had one quick question, if I may, for Charlotte, which was: is there a compelling policy reason why the qualifying cohabitation period for the cohab reform will be 3 years, whereas there is a different period under the 75 Act?
Yeah, I think there is, because parties haven't chosen to be separated on death. that relationship may have otherwise endured for years and years and years to come. So I do think that the period on death should be shorter because it's a relationship interrupted rather than a relationship that's been ended.
Okay, that's great. So Reece, now wrap this all up for
Yes.
us. Where does this leave the FRC, Talata, Inheritance Act claims, 1984 Act claims?
Yes.
Where are we all left? And final question, what's happened to compensation? Has it all been forgotten?
Well, yes. So that's a lot to rattle through in 30 seconds. So a plug, if I may, for Sharon's book, The Road to Equal Partnership. But she makes the point, she makes the excellent point in that book that there was a case some years ago called Miller and McFarlane. And in that, the House of Lords said that the leading principles were needs, sharing and compensation. And compensation has sort of dropped off the radar a bit. And the question that Sharon poses in her excellent book is, should we be, as currently is proposed, should we be hard baking the confusion that surrounds compensation at the moment into the legislation by downgrading it into just a Section 25 factor, or should it take its rightful place as an overarching principle? Don't have the answers to that, but certainly in Sharon's book, there's some very interesting questions asked about it. I'm bound to say I'm delighted to see that pensions are going to be expressly mentioned. I think there will need to be a wider look at the other statutes, Part 3 and things like that, and one would expect that everything is going to have to be upgraded and modernised to work in accordance with the way in which the lead statute will work, if I can put it that way. So far as the FRC is concerned, I think these are very interesting times. Emma and I wrote an article last year at the FRC, A New Horizon, where we list the sort of pleas from various presidents of the family division down the years as to why on earth Talata claims and Inheritance Act claims can't be brought in the Financial Remedies Court. And with this big moment of reform, I would suggest that it is a moment to have a look at the jurisdiction of the Financial Remedy Court and enlarge it to bring those claims in, so that there is a sort of a new super FRC that can deal with all of that legislation. And there's obviously lots of implications that flow from that, but we don't have time to discuss those this evening.
Right. Well, thank you very much. We only had an hour, but this is so much in this topic. We could gone on for several hours, but on this hot evening, you probably wouldn't have welcomed that. So thank you very much to everyone for listening. Thank you to the panel for your interesting views. I'm sure we shall be returning in future webinars to lots of these topics as this develops over the months and years ahead. So for tonight, thank you and good night.